Good morning, everybody. We'll convene the meeting of the Public Protection and Judiciary Committee. Amy, our clerk, is absent at the moment, doing some things, so I'll just acknowledge that we have all members present. And can I have a motion to approve our minutes from our last meeting?
So move.
Any second?
Second.
Any discussion on those?
Yeah.
Okay. They're approved. Thank you. Any public comment? Seeing no public comment, we'll go right to our business items. Today we're going to focus on just one topic, and that is the impact of alcoholism on St. Croix County from different perspectives of law enforcement and public protection. We'll start with the judges, and we're calling Judge Waterman first, and Judge Nordstrom. Then we'll move around the horn to our district attorney and to the sheriff's office, and to other folks that are with us today that see this in their jobs every day. So with that, I'll call on Judge Waterman.
Thank you, Mr. Fiedler. I want to preface my comments today by stating that I can share observations from our work, but sitting as judges, so we have to be impartial adjudicators of disputed issues of fact and law. We can't sit as policymakers. So if it comes to a question of whether a policy is wise or unwise, I'll leave that to you, the policymakers, and to others. But I can share observations of our work dealing with alcohol issues. I don't have any hard statistics today. Most of my observations are based on anecdotes. Probably the vast majority of our cases has alcohol as a substantial factor in the reason why people are in court. And it goes well beyond drunk driving cases. It goes well beyond bar fights. If you were to look at our criminal docket, another large part of our work has to do with domestic violence. Almost always, the perpetrator has consumed large amounts of alcohol, sometimes drugs or both, and that likely leads to the violence. Sometimes we see both the perpetrator and the victim consuming alcohol. And sometimes these domestic violence cases involve a lot of verbal abuse, yelling and shouting. They can escalate into physical violence, strangulation, even homicide. I can think of at least two cases, just off the top of my head, in the domestic violence area, where somebody was killed and alcohol was a substantial factor. That Fleischhauer homicide from a couple of years ago in New Richmond was one. I think Judge Nordstrand has a case that's currently pending where I believe alcohol is likely involved. Now, alcohol abuse is not restricted to our criminal docket. If we were to go into child protection, nearly 90% of our child protection cases involve usually drugs and alcohol. Meth remains the scourge, the primary problem, but alcohol is usually involved as well. The legal system, I think, does its best to protect children under those circumstances. But as a practical matter, the children living in those environments are watching their parents. They're learning from their parents. They're at a very impressionable age. And it puts these children at greater risk themselves for developing drug and alcohol problems in their later youth and adulthood. We see alcohol problems in our divorce cases, family law. A lot of times, marriages end because of one spouse's abuse of alcohol. A lot of times, divorcing parties will resort to alcohol to numb their senses and to cope with the stress and the anxiety of a difficult experience. Mental health. It's always in the news. We attended a symposium a couple of weeks ago. It's a statewide issue, statewide problem. We see people with mental health issues in all types of cases, not just mental health specific cases. And what I see frequently is folks who are either undiagnosed or untreated for their mental health, and they resort to alcohol and other drugs to self-medicate. And they get a temporary relief from their symptoms, but ultimately it leads to much larger and greater problems, oftentimes touching on the legal system. So I could go on, but I think you get the point. It's everywhere. Now, we as judges don't sit in a position where we can implement preventative solutions. We sit on the back end. We are adjudicating disputes. We're adjudicating events that have already happened, and usually bad things have happened. There are some things that we can do specifically related to alcohol abuse and use to try to change people's behavior. In the criminal area, we have justice services. We can refer people to justice services for monitoring, drug and alcohol testing, GPS zones to keep people out of bars in extreme cases. In criminal cases, we can refer people to treatment. We can add that to judgments of conviction and require people to get a drug and alcohol assessment, follow through on recommendations. We can refer people to treatment court. Treatment court still has the ability to address people with a substance use disorder involving alcohol, even though the OWI track has ended. We can also impose incarceration. We can send people to jail. We can send people to prison. So we have a lot of tools available to us, but ultimately it's the individuals who have to change. We can try to influence human behavior, but it's ultimately the humans themselves who are going to have to implement the change. Otherwise, we see them back, and quite frequently we do, dealing with the same problems. So that's just a brief overview. I know Judge Nordstrand has some additional comments.
So I would echo what Judge Waterman has said about the limitations of what a judge can do, not only in terms of the tools that we have on the bench when dealing with folks that come before us, but also the appropriate scope of what we advocate for, because we are the impartial arbiters that everyone relies upon to come to court, to get a fair hearing, and ultimately achieve justice in our system. So, with that being said, there are some, I think, some areas of discussion that you could talk about. One of the, I think as many of you may know, I'm a recovered alcoholic. So I speak from my own experience as well as seeing what's going on in court. So I have a sense of the difficulty faced by the folks who come before me with drug and alcohol addiction that probably is a little different than others. That said, all of our judges in this county, and frankly in every county, see the scourge of alcohol abuse and use. I'm going to just focus on the alcohol for a minute, because we can sort of distract ourselves from the alcohol problem by focusing on the drug problem. And meth is a scourge. It's terrible. It's destroying communities, it's destroying families. And for some reason, this part of the state is particularly impacted. But if I had to say, in terms of the cases that come before us, alcohol is a much bigger problem. You know, obviously its accessibility makes it much easier to get for everybody, including kids. The results are as or more dangerous. I think one of the things that folks don't realize is probably in terms of addiction, the only drug that likely, or that has the possibility of killing you as you withdraw, that I know of reasonably, is alcohol. It's a very dangerous drug to come off of, and I think this goes to some of what the Sheriff's Department will probably talk about, is just having adequate resources in our community to deal with folks who've been drinking heavily for a long period of time and then are taken into custody, and the challenges that that poses in trying to safely bring them down from their alcohol use. People die from that. We haven't had that experience here, I don't think, but that's a danger. Now, our tools, let's focus for a minute on the tools that we have. We have drunk drivers who come before us. I think Judge Waterman had 5 on his intake this week. Monday morning, 5 OWIs in St. Croix County. 4 2s and a 3, I think. So that gives you a sense of the scope of what's going on here. Each and every one of those cases could have involved, thankfully didn't, somebody getting killed or hurt. Because these are people that are driving without the capacity to, you know, maneuver the car effectively. And we've had, that's the other thing about, you know, Judge Waterman talked about homicides related to alcohol. I think we've got, I don't think they're not in my branch, but I think there are presently at least 3 homicide by intoxicated driver cases in St. Croix County, pending in various stages, that have happened within the last year. So that's how many victims we have that have, you know, suffered the ultimate price. That's pretty significant in a county of our size, I would say. Now then, you look on the other side, what can we do? Well, for OWI cases, we're charged with requiring an assessment of these folks when they're sentenced, an AODA assessment, alcohol and other drug abuse assessment. And then so they're assessed by our county. Under the statute, only one provider in the county can provide the assessment tool that the statute requires. And in our case, the county has accepted that responsibility and does the assessment. And then, based upon what they learn, they recommend a driver safety plan, which includes perhaps treatment and some other things, and they have to follow through with that treatment plan in order to ultimately get their license back. And so that's part of the process with an OWI. We also regularly require an AODA assessment for other cases that involve alcohol, obviously. You could have a disorderly conduct charge all the way up to a battery charge, to other consequential actions, domestic violence, various things, and we require that too. Now, in terms of the delivery of that, I'm not going to make any choice, I'm not going to make any advocacy here today about the choices that we make here as a county in terms of spending money. That's your job. I will say that we are aware that in the recent past, it's taken 9 months to get from the time that you're assessed until you get treatment in this county. Okay? That's different than a lot of counties. I know from talking to other judges. That's for you to assess whether that's a functional system or not. And I do know this, speaking as a treatment court judge, because for a period of time we couldn't add new people to the services at HHS, and so we had to close treatment court for a couple of months as a result in terms of new admissions. I know they're working on their wait list, and that's a good thing. But, you know, obviously, treatment in close proximity to the event is better. All right? I think because you avoid all potential other consequences. I have had a case where they were placed on I placed them on probation in an OWI case. I think it was a 3, which is a little unusual. Often that doesn't happen, but it did. And while they were on probation, they had a 4. I got a letter from the Department of Corrections here in St. Croix County that said, we're not going to revoke him because he was on a wait list for treatment and he couldn't get treatment. Now, that may be a little bit extreme in terms of excuses. You know, there are other ways to get treatment than through the county. You can get county through programs for change. You can get the county, or the county does refer you to other folks if there's a delay in getting it to. But that's a tangible example of our system and how it works. And I just want you to understand, I'm not saying go spend more money. I'm just saying that's the reality that we face here in St. Croix County. Now, one last thing I want to, we spend a lot of time, and I as a recovered alcoholic do enjoy hearing it all about how alcoholism is a disease, and we learn over and over alcoholism is a disease, and all these sort of mental health approach to this issue. Very good. I think we've got that. Alcoholism is a disease, it's a problem. The question is, what do we do to try to diminish the impact on our community? Some counties do, and I just throw this out there as an idea. We actually, I think, in a TAD grant proposal a few years back, had an IDIP proposal that was, we requested to sort of increase our TAD grant to help us start an intoxicated driver intervention program. It's something to think about. We don't have it. Other counties around us do. Pierce County does. I think Polk County does. I know Chippewa County does because I bothered to print out their form. What essentially it is it's sort of, treatment court light. It's because you can't convince somebody who's got a relatively small bit of jail time to face for an OWI, a low-level OWI charge, to do enormous things like go into treatment. We don't even want them in treatment court. It's not appropriate. But even if they wanted to come and we wanted to bring them, no one's going to go to treatment court for a year and a half because they face, 10 days or 30 days of jail. They're going to choose not to do that because it's the burdens of being in treatment court for a year and a half. But there's a way we can do this where we could develop a system where you can give sentencing consideration for an agreement to participate in a program that has some boundaries on this person. For example, in terms of periodic testing, random testing over a period of time. And I think in Chippewa County, it was eligible for anybody with more than one OWI arrest, no violent offenses, people who would be open to changing their alcohol and drug behaviors. You got to be willing, and people who can complete the program requirements. You got to remain alcohol-free throughout the program. You do a screening. You pay a fee. You phone in every Monday through Friday for random testing if you're called in. You submit to letting collateral information being collected. That's psychologists speak for talk to your family and friends, and you do some treatment. Maybe that's something we could look at because we've got a lot of this going on. And anyway, so that's the closest I'm going to come to a policy recommendation because it's out there. Other counties do it. As a matter of fact, Judge Waterman will probably back me up on this. We regularly get sentencings on OWIs where the lawyers come in and say, but Your Honor, you should do this. Other counties have this. And we get that all the time. You should reduce the sentence and do this program. And I say, well, we don't have the program. With that, I guess I'll conclude my comments.
Judge, I know both you and Judge Waterman are under time pressure because you've got cases starting at, or a trial starting at 8:30, so I'll just be very quick. On the latter point, the suggestion that what other counties do, who do you think is best, how do you think we would best go about trying to formulate that policy? Take a good look at it, bring the right people to the table, and then act on it? What would be the process you would suggest?
Well, we probably have a fairly good formulation because we made a proposal to the Department of Justice through their TAD grant. And Judge Waterman, I wasn't here then. Do you know how long ago that was?
I'd say probably 3 years ago. I think it was before COVID.
So I think the confines of what that would look like is probably out there. It costs some money, obviously, so it would require a certain amount of investment because there's a testing protocol and there's treatment, and you're going to run into people who don't have money to pay for these things. Though some might have the ability to pay, but I don't think it would be, and so many other counties do it, that I don't really think learning how to do it would be the challenge.
One last quick question, and we'll open it up to everybody else. You'd mentioned that we'd had a 9-month delay in our AODA testing. I know some of the counties around us have extremely less timeframes. Do you know roughly what some of those counties' timeframes are?
No, I mean, anecdotally, when the judges meet, we might talk about it a little bit. The only experience I've ever had recently about that is when I sentence people that are living in other counties, they talk to me about, sometimes they talk to me about, well, I've already had my assessment and I'm starting treatment. And I had one where I think the delay up in Barron County was 2-3 weeks. And that had been their experience. And so, because they happen to live there, and so you do the assessment where you live, all right? And because you want them to get the assessment where they're going to get the treatment. And so periodically we get a few of those, but I don't really know. But obviously, again, and I want to say that HHS is working to improve that. And I don't know what the number is now because it was 9 months for about a year because I would periodically check on it. But that's probably they started to change things in December when they made that decision to stop taking new clients because they had a wait list and they were working on it. So I don't know where they are now.
Other questions?
What's the primary reason it takes as long as 9 months? Lack of services?
I don't know. You'd have to talk to HHS, except I think a wait list develops, and people they have certain numbers of people and certain capabilities. I know for a period of time they had some staffing problems, people that had left, and that was what caused the crisis per se in December. There were other people that they were relying upon to deliver services were leaving, and so that sort of really brought it to a head. But
there's also certain cases I prioritize, so if you're not a prioritized one, you keep getting bumped. So for opiate related, heroin, fentanyl, people in custody, I can't remember what the other classes are, but
pregnant women, women with children,
yeah, certainly.
it's groups of people that you'd think should get priority.
Right, but if you're just alcohol, not in custody, they end up getting bumped.
Supervisor Leaf?
So it's discouraging when you hear the 3rd and 4th or 5th, 6th, whatever number of DWIs. We have a cultural problem in this state with alcohol, that's for sure. Every place you go, every festival, every this, every that, right? So you're right, children see this in their parents. But I wonder about what is somebody who gets their 3rd DWI, I mean, don't they get jail time, or is that up to, I mean, I wonder what choices, like what can we do to make the sentencing guidelines maybe stricter to maybe make an impression, right?
Yeah, it's a great point. I once gave a talk because I had a conversation with my brother-in-law about when I was a new judge, it's OWI number 6 or 7. And he was just astonished, like you were. I mean, how does somebody get to OWI 6 or 7? And then it dawned on me, I know exactly how they got there. They got there first and they got a fine. They got their second, they got 10 days of jail. They got their third and they had 60 days of jail. Fourth, 180 days. So the jail just piles up. It's an escalating sentence structure. And we can debate whether or not jail has an effect on changing this type of behavior, especially when addiction's involved, because, you know, it wouldn't take me 180 days of jail to change my behavior. It wouldn't take one day. And I think most of us can conform our behavior without even experiencing a day in jail. But we have a population, a small population, that doesn't. And that was one of the reasons why we started the OWI track, is because there was a population, I can't remember what the exact number was, small, but a significant population that no matter how much jail, how much prison you get, they will just reoffend. And the frustration that we have as judges is that we're faced with sentencing guidelines, which I think provide some degree of consistency, but we also have maximum sentences. No OWI offense, absent a homicide, is ever going to involve life imprisonment. So at some point, these folks are going to come back into the community. Even if they serve years in prison, they will eventually be released. What is it that the system is doing to prepare those people for release so they don't reoffend? And that's beyond the judge's involvement. That's something probably for the Department of Corrections. But there is a problem there because we keep seeing the same people coming back. And you have the same conversations with them about their problem and their need to change and so on and so forth. But it doesn't.
Supervisor Adams.
As pertains to the OWI, is there ever a time that we confiscate vehicles? Or, have their driver's license revoked, confiscate a vehicle, and even that's tough because that might be the family vehicle that's needed by that person's household.
I think the OWI laws some time ago did include the possibility of vehicle forfeiture. I don't believe that they do now, so it's not an option. Maybe the district attorney would know about that more than I do, but I've never seen a vehicle forfeiture in an OWI case. In Wisconsin. I know Minnesota used to do it. I don't know if they still do.
I think they do.
Do they? Yeah. But it does involve license revocation, starting from the first offense, 6 months, second offense, 12 months, third offense, it just keeps going up, 36 months. Fourth offense, it's a lifetime revocation. The other side of that, too, is that you don't need a license to drive. You need a license to drive legally. And you should have been in court yesterday because we have all of the driving offenses associated with people with revoked licenses who continue to drive. And that's a problem. I don't know what the solution is, but it's a tough problem.
Mr. Chairman?
Judge Hartson.
So, yeah, if you want to see something interesting, come by every Wednesday and see all the people with what we call OARs, operating after revocation. So, you can take away their license all you want, and you can't imagine the excuses. There's a lot of good ones, right? But the reality is it doesn't have that impact. And, when you see these high-level OWIs, one thing that we can and do is when folks are sentenced to prison terms, they have treatment in prison. And they can, it's complicated, though, because I've had recent experiences where people with OWI sentences to prison, and there's mandatory minimum sentences. So 5s and 6s have to have a year and a half generally, though it can be reduced to a year. 7, 8, and 9 is 3-year minimum in prison, in custody, and that's not subject to reduction, that's required. There are very many things in the statute that have required incarceration, but OWIs at that level do. And so while they're in prison, there are actually prisons that are treatment prisons. I've toured the one in Chippewa Falls. It's an old mental hospital, I think, that's been converted into a prison to be used only for treatment. And so people can get treatment in prison, and hopefully that is of some help. I don't know if we know what the outcome of that is, but that's one way to get people some help. If we're just sentencing them to, 6 months in the county jail, I don't know, as much as the sheriff may want to provide some services, there's really not a lot of in-custody treatment there in a real way. Though certainly they can go to AA meetings and NA meetings and those kinds of things, and they can get some services brought in. But it's not conducive to that, like a prison setting that's set for treatment. So just on the upside, there is that. The prison system provides that. But you have to actually get admitted, and that can be problematic. Part of the impetus to that program is it's a way to reduce prison populations, because people get out early. They get released early. The early release program, one of the only ways to do that is to go through treatment. And so the Department of Corrections selects who gets in that program. And to some degree, I think it's fair to say that they look for people where the sentence would be reduced significantly, and OWIs have a mandatory sentence that can't be reduced. So to some degree, it sounds crazy, but there could be a situation where OWI folks would be less capable of getting in because they don't have any sentence advantage in terms of doing the treatment. Whereas somebody, say, convicted of dealing meth gets 2 years incarceration. If they go through that program in 6 months to 8 months, they can be released. And so 2 years turns into 8 months of incarceration. So there's a positive for the system. And, we have to respect that that's the Department of Corrections' job. But anyway, that's just one other aspect of this complicated problem.
Judge, I would just note that I was at treatment court a couple of weeks ago, and you had a young man in there, and he had arrived in his vehicle driving after revocation, and the sheriff's office representative who was there really got after him in court and said, I'm going to be watching you when you leave, and you are not going to leave this parking lot in the car you drove in on because you don't have a license. And I just was thinking, boy, I just acknowledged the problem that you cited there. Judges, I'm looking at the clock. You folks are due up in court. Thank you so much for being with us today, and I really appreciate your observations. Thank you so much. I'll turn to the district attorney now. He's kind of the person, the gatekeeper, as it were, to everything that happens. So our district attorney, Carl Anderson.
Yeah, so I think as both the judges mentioned, there's certain crimes that we expect to see alcohol, frankly. One of them is domestics. A domestic case that doesn't involve alcohol is pretty much the exception. Obviously, the other concern, like we've been talking about, is drunk driving. I ran some quick numbers. In 2022, we had 287 cases of OWI. In 2017, we had 244, so 5 years previously. That's about a 17% increase, while the county increased 7%. So you can't say that means that there's more drunk drivers. It could also just be more enforcement by police. But I thought that was noteworthy. And that's not just a randomly high year and a randomly low year. I looked at the last 6 years, and that's the trend.
Carl, your office prosecutes all cases that come from the county and from the municipalities, correct?
Yeah, well, actually, municipalities, OWI first, because we're the only state in the country where first offense is not criminal. First offenses are handled by municipal judges, municipal courts. Unless there's a criminal charge also, then we'll take the whole case. But if it's just OWI 1 in Hudson, it's handled in Hudson Municipal Court. We do all the OWI 1s, though, for the Sheriff's Department and State Patrol, because they don't have municipal courts. So if we're...
So the number 244 yeah, it could be much, much larger if we added in the first OWI cases.
Correct. And if so far, I mean, in the first 4 months of this year, we had 99 OWI cases. If that continues, we'd be at 300. And compared to 6 years ago, that's a 30% increase. So part of it could be increased enforcement by law enforcement, and yeah, the typical time we see a lot of or alcohol-related cases is Monday at intake. You know, there's a lot of alcohol arrests over the weekend. Like Judge Nordstrand mentioned, there was 5 repeat OWI offenders this Monday. 2 of those were crashes. 1 was driving the wrong way on the highway. Thankfully, nobody was injured in any of those, but obviously, our 3 pending intentional homicides are all alcohol-related. So there's no easy solution, otherwise somebody would have thought of it. and yeah, I mean, we've seen OWI 4s are not uncommon. That's a felony. That's mandatory prison. It's the first mandatory prison offense. But we also see 8s, 9s, 10s, and 11s are rare. But if you look back at the criminal history of somebody with like a 9 or 10 OWI, they basically will go to prison, get out, get a new one, go to prison, get out, get a new one, and they spend most of their lives in prison while they're racking up all these cases. Yeah, and the challenges we see is access to treatment, I would say, is the biggest challenge, especially people who need inpatient treatment. That can be a really big challenge. Part of it is not all inpatient treatments accept all forms of insurance. Part of it is there's wait lists at every inpatient place I've ever heard of. That's probably the biggest challenge I see that potentially has an easy solution, and if we had more inpatient treatment facilities, but they're all private or nonprofit. Yeah, it's a big problem, and I unfortunately don't have an easy solution for you all. Yeah.
Chair, so is there any kind of way that we put those devices on vehicles that you have to breathe into it?
Yeah, so for a first offense, if they're higher than a .15, it's mandatory. And for every OWI after that, it's mandatory. And there's 2 ways their license are restricted that we call them IID, ignition interlock device. If you have an IID order on your license, 1, your prohibited limit changes from .08 to .02. So anybody with an IID order on their license, they're a .02. They also have to have any vehicle titled to them, has to have an IID installed, and they can't drive any vehicle unless it has an IID. So they can't just drive their friend's car and be fine. The problem is a lot of people don't do it. You know, the legislature has tried over the years to address the drunk driving problem. I've never heard of the penalties getting lighter. They're always getting steeper. OWI 4s, when I started, was not a mandatory prison. It became mandatory prison, I think like 3 years ago. And now also for OWI 4s, they lose their license for life, which on its face sounds good. The reality is nobody wants to drink and drive stops because they don't have a license. You know, if they're drunk and they want more booze, they go whether they have a license or not. So, yeah, that was a long answer to your question. Yes, it's required in almost all cases. The amount of people who actually do it is probably low. The ones who actually go out and do it are the ones who are able to self-correct, and, you know, we're trying to follow the rules.
How do they get a hold of those ankle bracelets and then those breathing things, and how are they funded? Where do they come from?
That's one reason why a lot of defendants don't do it. The defendant has to pay for it, and they're really expensive, hundreds of dollars a month. I think they're like $400 a month. Yes. The ankle, they're expensive too. Those aren't really used in OWIs. Are you talking about like a GPS device? Yeah, they don't really use those in OWIs. Those are usually when we ask for a GPS condition, it's for like a stalking case to make sure they're not going near the victim's house or residence, or if it's somebody who we're just worried is going to try to flee, but they're not in custody. They posted bond or something.
Carl, were you familiar with what Judge Nordstrom was saying about some of the treatments that could occur pre-charging? Or I'm not quite sure when that kicked. Were you familiar with that? What some
Yeah,
other counties are doing?
IDIP programs, the way they're structured is we have OWI guidelines. Every county by statute is required to have guidelines on sentences for OWIs as far as length of revocation, length of an IID restriction, length of jail. And IDIP programs will say, okay, you can have the guidelines of 10 days jail for an OWI second, or if you do this IDIP program, you'll get 5 days jail, but you have to be subject to testing and treatment, and that it's a bigger difference as you go up for a third. People might get 45 days jail without an IDIP, and maybe 20 or 15 with an IDIP. Actually, no, 45 is the minimum on a third. So, but it's a minimum guidelines. It's not a statutory minimum. So the counties that do it, they say, we'll give you the absolute statutory minimum, but you have to do this program. And then the incentive is they get less jail. The benefit to the community is they're forced to get treatment and stay sober, basically.
Thank you, Chair. Are those guidelines done by the state, the variables in the guidelines too, with the different programs?
The guidelines are done by judicial district. So we're in the 10th judicial district. So I don't know exactly how they come up with them. They must have some sort of committee with the judges from the district, and then it's approved by the chief judge of the district. And I think the reason that started was because, which is still an issue, is some counties, the going rate for an OWI 3 is vastly different than a county 3 counties over. I think we're consistent with most counties, but there are definitely some outliers.
Carlson.
Are these IDIP programs in other counties, do we know if they're efficient or successful?
I don't know. I don't know if there's been studies on them or not. That's a good question.
Any other questions for the DA or any other observations, Carl, you'd like to make about our problem with alcoholism in the county? I know Judge Nordstrom kind of touched on it a little bit and maybe Mr. Gawley, when he makes any comments later, was about placement of people that had problems, not necessarily those that were in the criminal justice system, but just those that had a problem. And at our last board meeting, we had a request to do a big study as to whether we had a proper facility in the county that might be able to take care of folks, at least in the initial stages of trying to address their problem. Are you familiar with what the HHS board is doing on that? And has it been your experience that finding a proper location to help these people is a big problem? I think you alluded to that earlier.
Yeah, it absolutely is. And I'm assuming same as everywhere, it comes down to cost. Treatment's expensive. I think I will say that counties that have IDIP programs, they're run out of departments similar to like JSC. So if we had an IDIP program, it'd probably be part of JSC, but I imagine they need staffing to do that.
Ooh, I keep thinking of things, sorry.
Yeah.
On the surface, as our population grows, it's probably expected that the incidences is going to grow. And you alluded to the percent, like what, 9% increase in population and a 12% or 16%?
7 and 17.
7 and 17, close. And I love sevens. But how about years ago? I mean, the people that we speak to, you know, on the street I can see them saying, well, we have we have such a larger population now, of course we're going to have more in numbers, but in percentages is the key there that granted, like you said, it could be more enforcement or whatnot, but all things considered, it is a higher percentage.
Right.
Okay, thank you.
Yeah, it's increased faster than the population has, by more than double in the last 5 years, percentage points wise.
I know Carl had a couple of cases he had to run up to as well, so unless there's any other questions, thank you so much for being with us today.
Thank you, everyone.
We'll call on our, Sheriff Knutson was not in town today, I believe, and so we are privileged to have his chief deputy with us. Thank you so much, and we look forward to hearing from the sheriffs.
Good morning,
Your
Mr.
observation from your perspective.
Good morning, Mr. Chair. The sheriff sends his regards. He's at a sheriff's conference this week, so I think as far as alcohol's impacts on our office, I want to touch on three things. One is enforcement. One is the impacts on children, and lastly, which is special to the sheriff's office across the state, for law enforcement, is the impacts of our jail. So touch on enforcement first, which for our office is traffic crashes, OWI enforcement, and then dealing with other crimes that alcohol is involved, mainly domestics, but daily we respond to these calls, whether it's OWIs and domestics. High percentage, very high percentage involve alcohol, way over 50%, probably 75%, if I had to throw out a number anecdotally. But they're also very time intensive. It takes a long time to process an OWI arrest, a couple of hours. The defense of OWIs has incrementally become more challenging, which I also think is a good thing. Defendants deserve a vigorous defense, and that makes us do our jobs better. But it takes time to do your jobs better. But that being said, I would much rather process an OWI than a fatal crash scene. So very high percentage of our fatal crashes are OWI related. And the impacts on families, children, the motoring public is pretty high. And then a number of those cases end up turning into us assisting child services, going to homes, and the impacts of children not being supervised is either they're in danger because nobody's there to watch them, they don't have enough food. We get involved and assist children's services to go do a home survey to make sure they have enough food, that they're being cared for. And a lot of times that lack of supervision, the children are involved in committing crimes on their own. So there's kind of two things going on there with the children not being supervised. And then the impacts of our jail. A lot of times when people come in that are addicted to alcohol, they will let us know. They know that if they're going through withdrawals, we better watch them. And sometimes it causes a hospitalization so they can get stabilized for their alcohol withdrawal. Judge Nordstrand alluded to it earlier that it can be deadly, and we've seen that in the jail. They're very high supervision inmates until we can finally get some of them stabilized. And they're aware of it. They don't want to be in that situation, but they are. It's a disease and they can't stop. So, today's jail population was about 112 in our facility today. To actually get the numbers on the percentage that are alcohol related is fairly difficult, but I think that's something I could get together for the chair. Because I can tell you who's there on a particular charge, and if it's OWI related, that's easy. But once they serve their sentence and they get onto probation or are on parole and get sanctioned, then that gets a little more difficult to determine whether it's an OWI related charge. But very high percentage of the inmates that are in our jail also have underlying alcoholism and alcohol problems.
I was just going to say, for example, also, if you had a domestic violence case, you might be arresting them for a battery charge, but it was as a result of having too much alcohol, but the alcohol doesn't show up in the charge. So it's alcohol-related, but it's not in the charge, so it's very difficult to get a statistic on alcohol-related, and I think we all understand that.
Yes, absolutely.
I think Judge Nordstrom referred to this, mentioning that you did your best when you had an inmate for a time, if they had an alcohol problem, to do something to treat them, to educate them on it. Could you just mention some of the things that occur in the jail with regard to that?
Well, and we have a number of programs that are alcohol related in the jail that the inmates can attend AA. And our program coordinator does a really good job of getting programs into the jail. However, they have, and a lot of them do like to go, and the programs are well attended. But the follow through after they leave our facility, I don't know how that goes. You can, and especially if you're sentenced to the jail for 30 days after an OWI, you attend these classes. Is there follow through afterward? The aftercare is really a thing that I think we don't have control over. And I think that's when things start to go off the rails, is when they get out of our facility. Their life is unstable and they don't have that support anymore.
Supervisor Rambert.
Thank you, Mr. Chair. Speaking of the collateral information that the judge was talking about earlier, and I'm sure the Sheriff's Department gets their fair share of excuses when you stop people. And one of the excuses I was thinking of as we were talking about the treatment centers is the Sheriff's Department would say, how come you didn't stop how come you sped up and took off when I tried to stop you? One of the excuses could probably be, well, my husband is in the treatment center and I thought you were bringing him back. So I was thinking of some of the fears that the family has when they're in there. And as far as the collateral, I thought that was such an interesting comment, the collateral information. Do we get collateral information when we're bringing people into the jail and have the alcohol issues and the hospitalizations that you know of?
Probably not.
Yeah.
Not a whole lot is focused other than on stabilizing the inmate,
Yeah.
and that is really all we focus on. So no, probably not.
Thank you.
Judge Nordstrom was very careful in indicating that neither he or Judge Waterman wanted to suggest that what they were saying was a policy suggestion, but they had some ideas that other counties had done, and they shared them with us. Would you have any thoughts that you might be able to express within the bounds of what any ethical restrictions you think are on you or the sheriff's office relative to policies that the county could implement that would be helpful at any end of the spectrum with regard to alcoholism, particularly in law enforcement end?
Well, from our perspective as law enforcement, we're kind of stuck in the middle part of this whole process of the use and after the arrest and the aftercare from an arrest. So my thought has evolved over the years that for any problem like this, including drug abuse, we are not going to arrest ourselves out of the problem. Arresting and throwing people in jail is not, it hasn't worked in the past, it's not going to work in the future, so we need to find other avenues to tackle this issue. So we would support any efforts to get people to not drink and drive, to get drunk and beat up their spouse. On the front end of that, it's hard for law enforcement to get involved, and I don't think that's our place. On the back end, we've made so many strides with first having the day report center, transitioning that over to JSC, and holding people accountable. And anecdotally, speaking to these people, they thrive actually under the routine that they get into. That's what they need. We would be supportive of efforts to, especially when we're talking people that are getting in their second, third, fourth OWIs, it's clear that there's an underlying issue there that they can't stop on their own. So the program that the judge mentioned, maybe that has some merit.
Well, I can relate to all of the different levels coming from a family history of alcoholism. And so I relate to how it happens, you know, being the parent, being the child, to the parents, to the disease, to the death. So in our line of work in child support, we are there in the best interest of the children financially. And we do not create orders. That's the judge's end. We get referrals because they're no longer a household of a mother, father, and a child, or mother, you know, the idea of family. So if alcoholism has created some sort of issue in the household, and the parents are no longer there to care for the children, we get referrals if the children are removed from the home. That says, okay, the state is protecting the children, therefore the parent should be financially responsible to help the state support their children. Or a parent is no longer able to have health insurance, they go on Badger Care. You lose your job, you go on Badger Care because of the alcoholism. We get referrals from economic support in realm of assisting the state financially and the children financially in supporting the family as a whole. So the judges create the orders. We bring the cases before the court to establish those orders in the best interest of those children, financially and medically. So if on the other end of it, if there's a victim, we're creating the safety for those individuals, creating a process for that, and we're working on that. For the perpetrator, or the absent parent, as we call it sometimes, not a deadbeat parent, but an absent parent. Because of the reasons of their absence, they might not have the financial stability to support their family anymore. And so it's up to the court to decide, is it appropriate to enter orders for this individual based on the financial ramifications of getting in trouble for alcohol. It's extraordinary, the fines and the fees, the attorneys, you know, everything that, you know, you can think of is their financial, you know, livelihood is down to the bottom. So they've reached the bottom at some point, and then we're going in asking you to support the family. Some of the spouses of these families are very considerate of the disease and would prefer them to get help. Get help for the disease, get your life on track, then we can talk about the financial end. So we do get a lot of agreements where parties have agreed no support for the children while you're doing this, this, or this. But if a court orders a parent to pay child support, we are the enforcers, so we're going to try to do whatever we can to get you to pay that support. Sometimes we might do administrative actions in lieu of paying the support. So if you're going through all these criminal things or all this treatment, we might say, okay, we're not going to take any administrative action or enforcement action against you until you finish this or this or this. So we are, although we can't, we're not a judge to say you can't pay you're not supposed to pay your support, we can try to get them to a point or to employment that they can start supporting themselves and the children. Because if you can't support yourself, you're not going to be able to support your family. So it's just the evolution. And if you fail to pay and you ignore our office in all of these attempts to get you to pay or get you to the workforce resource, the job center, to get a job, to get on your feet, whether it's through justice services or through treatment through HHS, you know, we hear all kinds of different things in regards to why I can't pay. What are you doing to get to the level that you can pay your support? And the courts are pretty good at, you know, taking good testimony, finding out the underlying issues in consideration of the children need to be supported. So, you know, they have to make the hard decisions. I don't make the hard decisions, but we can lax on the enforcement end of things if, as a collaboration, we're all working together, and that's what we're trying to do with in justice services. We're trying to get that collaboration to get that.
Questions for Lisa?
You mentioned workforce resources. Do you have like a smorgasbord of companies that you can share with them?
Yes, Workforce Resources is in St. Croix County. That's the program for our job service. They do our W-2 program for Health and Human Services. They have the FSET program. They have the work program where they put them through an extensive, you know, they go through an assessment just like they do for any type of treatment. And what are your needs? Is it schooling? Is it, you know, this? Is it that? Get them into schooling, help them financially with gas maybe. So getting them to employers that maybe have a carpool. Or if you can't drive, you know, some big employers might have a van or something that, or, you know, get them in touch with employers that could help them. You know, trust is there. If you know, you have all these criminal actions, what employer is going to trust you to work for them? So WRI works with the employers and the employees and try to get that, you know, getting them into the right positions, the right jobs. If someone is, let's say, a doctor and they get in trouble and they lose their license, are they going to go work for Seek Services to do some boxes over at Amazon, you know, or something like that? So you have to look at the level of the, is it better to get that person treatment to get back into their field of expertise to help the family at the level they're used to? there's all kinds of different things. But hopefully with the collaboration that we're starting now and working together, we will be able to get, help individuals get from the bottom to at least to the middle to where they can support themselves and feel happy that they're, helping their family.
Thank you, Lisa. I was going to call on Mr. Gottlieb next, but before I do, I just had a thought, and before the chief deputy had to leave, I wanted to just ask him another question. It doesn't deal specifically with alcohol, but it does deal with impairment. I was listening to some program out of Madison the other day on their Public Protection Committee meeting, and a witness made some comment like they believed that over 55% of the drivers in Colorado at any given time were high on marijuana. Now, you don't have to comment on that, but the question is, do we do any testing when you pull somebody over who you believe is impaired and you smell the marijuana? Do you test them for THC?
There are field tests that are designed to determine whether people are impaired on things other than alcohol. So we do have people in the county that are trained in that. If we do suspect somebody is driving impaired while under THC or some other controlled substance, generally we will take them to the hospital and request the testing from the Lab of Hygiene in the state of Wisconsin is the one that does some of that testing for OWIs, and mark that on the form to test the blood for those extra items.
Sure, thank you. So I'll just make a couple comments and try to keep them brief. I think the first place to start is with what's been discussed and what Judge Nordstrand brought up, the IDIP program, which I think is a great idea. We, as has been discussed in treatment court, we've gone away from our track 2, so serving the drinking and driving clients, but those clients aren't going away. They're still a need, right? And so I think for us to find a path forward to serve those folks is a great idea, and I think IDIP is something we can explore. Would fit nicely with our TAD grant, so I think that can be something that we apply. So the Treatment Alternatives and Diversion, which partly funds our treatment court as well as our diversion program, we can add or ask for, if it's available, additional funding for 2024 for the state. So that's something that my department can undertake. I would I will need to do some research on a startup cost. Yeah, so there is some background that I'll have to do, but I think there's a path forward for that. I do, and I think that would help. So more to come on that. I guess we can continue to talk about that. But I think it would fit appropriately in our department, as Carl alluded to. The second thing I'll talk about is compliance. We've talked a lot about that here from Carl's standpoint and from Brent's standpoint and from the judge's standpoint. That's a huge part of what we do with PP&J, obviously. We do that in justice services for conditions of bond, and that's fine, but that doesn't change behavior. What does change behavior is changing cognition and those thinking errors, or what are maybe broadly referred to as criminal thinking errors. So to the extent that we can continue doing our MRT, our moral recognition therapy, and other types of programs like that, that's what's going to help us as we move forward. Certainly there are consequences, jail, prosecution, but I think if we want to look towards the future, how can we incentivize people to change? I couldn't agree more with Brent, his comment about we can't arrest our way out of these problems. We've tried that, not here, but just across the country. I mean, that's been something that's been tried, and it's unsuccessful. And so what can we do to help people, because it's, the onus is on them to make that change, but what can we do to help them change and offer that change up? I mean, we're doing a lot of these things right now, but I think if we can continue to think that way for the future, that might be beneficial for us.
Chair.
Supervisor Adams.
I'm just curious if there is an age range that we're seeing that is the primary offender?
I could take a guess. I would go as low as 18 because those are adults and those who we work with, up to, are you talking about for OVI offenses?
Yes.
And alcohol-related offenses, excuse me. I would say through well into adulthood. I don't know. I would say all the way into their 60s maybe, if we're talking about domestic-related offenses. I think it really kind of spans the entire, life.
And so that leads me to ask, is there any possible success in trying to talk to citizens in that 16, 17, 18-year range that maybe we can begin to mitigate some of this early on? Because, I mean, if we don't, start pulling the weeds out of the garden early, you're just going to get more weeds, There's just no way out of it, it seems.
Yeah, I mean, prevention efforts are really important. Those are popular across the country, DARE and those types of programs. And so the more that we can do for prevention, because once they are arrested or prosecuted or in the courtroom or come to justice services, that's intervention at that point.
Right.
And that's right. And that's better than nothing, but to the extent that we can capture kids, that would be ideal.
You mentioned we'd gotten away from track 2 in the treatment course. Could you just go back and just review why we did that, how that happened?
Sure. So largely driven by legislation that there's not a ton of incentive for somebody who has accumulated a number of OVIs because they have mandatory prison waiting for them. I still do believe that there is a path forward to work with those folks, that even though they may be awaiting a year in jail or a year plus in prison, we can still find a way to incentivize them to change their behavior. Because those problems, I understand the legal ramifications, but those problems will be waiting for them after they spend a year in jail or after they're in prison for, over a year. And certainly the jail does great programming, DOC does programming, but what can we do also to incentivize them? And maybe it is the IDIP program. I know other treatment courts across the state struggle with this. We were at a treatment court conference last week, and I talked to the treatment court coordinator for the state, who had said that other counties have had to make adjustments as well. So this is something that other parts of Wisconsin are also dealing with. But yeah, it was largely due to legislation and how do we incentivize people to change.
If I could take just a minute to, thank you very much, Phil, to just comment on a couple of things. Our medical examiner is on a very well-deserved vacation this week, so she's not with us. She'd shared some documents with us that we all have dealing with the burden of binge drinking in St. Croix County, and it basically reflects that we have a problem. The economic cost to the county overall is $65 million a year, most of it in lost productivity. But you've got the forms in front of you that reflect the numbers of hospitalizations, deaths, and related injuries. And I know in doing some research on this, the thing that astonished me was the number of hospitalizations and deaths that resulted from falls as a result of alcoholism, particularly with seniors. And it's just an astonishing figure as to what it's costing us as a nation. One of the things that I was hoping we would do from what we're doing with this particular meeting is have a couple of action items going forward. I think Judge Nordstrom alluded to one thing. I think Phil kind of took up the mantle of it just a moment ago by suggesting that he would look into some of these things and come back to us with some ideas, look at the previous TAD grant that was referred to, and maybe, I don't want to push you on that, Phil, but maybe a couple of months from now, if that gives you enough time to take a look at that and come back to us with a firm recommendation. The last opportunity we would have to do something this year would be in our budget for 2024, which is very tight. So we may or may not have any expectation of being able to do something then, but would certainly like to hear some ideas as to what could be done. Also, just to go back momentarily, in January, the medical examiner brought to our attention a number of deaths that she had seen relative to very young people, that cirrhosis of the liver, alcohol damage, and others in the middle age. And that got us all thinking about, is there a duty we had to look into this issue more deeply? And the result was that we tentatively were then going to meet with the Health and Human Services Board jointly in mid-May and have a program on this. And the way it initially started out, we were going to have this kind of meeting with the DA, the judges, the sheriff's office, others who would talk about, from a law enforcement perspective, what the scope of the problem was. And the HHS board and staff in New Richmond and others in the county would talk about what some of the aspects of alcoholism were and what the county now provided, and also perhaps have ideas as to what they could do better in the future to address the problem, not only of criminal alcoholics, but just alcoholism generally in the county. As it evolved, the latter half of that idea seemed to prevail for the May 17th program that will be held in New Richmond at the Technical College starting at 5:30. And it should be a very good program. And I would recommend we all try to attend it if we can, to get a feeling about what's happening on the Health and Human Services side of delivery of services to that. But because it was so full of that portion of the program, there was no longer what was the scope of the problem from a law enforcement perspective. Therefore, I asked if it would be appropriate for us to then meet, as we are today, to hear from the people we've heard from today, to hear that, but also with the goal of coming away with some action items. So I would just leave that thought with everybody who's here. I've talked with the judges a little bit about it. We just heard Phil would volunteer to come back to us in a couple months with an idea, and that's great. I know the medical examiner had done something like this about 4 years ago with regard to drugs. And what she had done at that time was approach an insurance company and convince them that they would save money if they supported a educational program in our schools relative to drugs. And they did support that. And among other things that they did, they spent a lot of money on a very, very fine pamphlet that described all aspects of drug addiction. And I know that the medical examiner thought maybe the same thing, as appropriate, could be done relative to alcoholism, and that we could again approach an appropriate entity or entities in the county or otherwise to have them fund the distribution of educational materials relative to alcoholism, and that perhaps the various offices in the county, be it the sheriff's office or other parts of the county as appropriate, could think about what they could do to make one more step in that educational process, to try to, the preventive educational process, before we see them before the justice system. And so hopefully that will, when Patty gets back, I'll chat with her further about this, and we might be able to come back in again a month or two with some action item relative to some kind of well, we've talked about incentives several times, but incentives or educational programs that would occur probably in the fall or winter, and hopefully at very little cost to the county, that might address this problem in the county. Other observations from folks? Thank you, everybody, for being with us today. I think we accomplished our goal to shed light on what the scope of the problem is. And again, encourage everybody to attend that May 17 program of the Health and Human Services Board up at Technical College Northwood in New Richmond. And that should be a good program as well. Thank you again. Let's see, technically we'll go through requests for future agenda items. Seeing none. Announcements? Oh, I'm sorry. Oh, in fact, I know we've got a couple of future agenda items. Phil's going to come to us in June with suggested modifications to some of the fee structure within his office. And I know we've also got coming up the zoning issue that came up to us a month and a half ago, and Tim has done some good work on that, and he's been working with the corporate council. We may have a couple of amendments to what was in front of us then, but I think that'll be perfected over the next couple of weeks and shared with the committee members. And so those two things for sure will be on our agenda in June. Are there any other items that people would like to raise? If not, any announcements and correspondence? Seeing none. Our next meeting, I believe, is June 1st. I don't have my calendar in front of me. But anyway, our next meeting will be as scheduled in early June. I think it's June 1st. And with that, thank you all for being with us. And June 1st. And we are adjourned. Thank you.